Welcome back to the channel, everyone. Today, we have a dramatic update from the ongoing YSL RICO trial involving rapper Young Thug. Attorney Brian Steele, representing Young Thug, has been taken into custody for contempt of court. Let's break down what happened and why this is such a significant development. On Monday, things got heated in the courtroom when attorney Brian Steele refused to disclose a source of information regarding a private conversation between Judge Earl Glanville, the state, and key witness Kenneth Copeland. This led to a tense exchange that ended with Steele being held in contempt of court.
Thank you.
Yo, go ahead.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland and this court, were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm not disturbed too. And the reason...
Well, I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you, Mr. Adams, meet with me, and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to...
No. I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
yes. A witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going
Well-
to say is this. I was told, and I hope this concerns the court.
It
I was
concerns me that you have proprietary information.
Why is it
Or
proprietary?
information that you should not be having that was ex parte
Why?
with a party,
Why?
state of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly
That's
this honorable court,
Okay.
or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I
I'm doing
still
what
want to know,
everybody should.
how did you come upon this information? Who told you?
What I want to know is why wasn't I there? Why,
Sir, I'm going to hold you in contempt if you don't tell me who that.
I'm not- I-
Tell me who this
I
information
don't
was
want to be
coming
held
from.
in contempt.
Well,
I'm not
then-
answering that question. That's attorney-client privilege information. I am not answering.
Attorney-client privilege, unless you were in my chambers, that's the only way you can figure out.
I am
I
telling
tell you what, I'm going to give you 5 minutes. If you don't tell me
Don't
who
have
it is,
to. I'm
if
gonna-
you don't tell me who it is, I'm going to put you.
Let me-
I'm going to put you in contempt
I
because
understand.
that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was, don't take my notes. No.
Judge Glanville repeatedly asked Steele to reveal how he obtained the information, emphasizing the importance of confidentiality in such matters. Steele, however, stood his ground and refused, leading to his temporary custody. Let's take a look at what was said in the courtroom.
You all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again? Sir, you have to. Well, you're gonna have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever, this morning that.
If there's any accuracy to some of the information that we are.
But sir, I don't even know. Your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No, it's not, sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir. We're going to be in recess for the next 5 minutes.
After refusing to comply, Steele motioned for a mistrial, which was denied. He was then taken into custody. The court temporarily recessed, and when it resumed, Judge Glanville reiterated his demand. Steele was given until the end of the day to reveal his source or face further custody. In an update on Monday evening, Judge Glanville ordered that Steele be held in the Fulton County Jail for no more than 20 days for this contempt. Specifically, Steele will serve this time over the next 10 weekends, reporting to jail on Friday evenings and being released on Sundays. This trial has already been a long and complex one. Young Thug, whose legal name is Jeffrey Williams, has been behind bars since his arrest on May 9, 2022. The case centers around allegations that his YSL label is actually a front for a violent gang known as Young Slime Life, with Williams allegedly being its kingpin. The trial began in earnest in November 2023, and it's already considered the longest in Georgia's history. As it continues, the legal battles and courtroom drama show no signs of slowing down. We'll keep you updated with all the key developments. What do you think about Brian Steele's refusal to reveal his source and the resulting contempt of court charge? Do you think this will impact Young Thug's case? Let us know your thoughts in the comments below. Don't forget to like, subscribe, and hit the bell icon to stay updated with all our content. Thanks for watching, and see you next time.